difference.
No. May I please, your Lordship. Lordship, I'm appearing on behalf of Mr. A. Khalid, Lordship.
Yes.
Lordship, he could not come to some due to some personal difficulties, he could not come to the court, Lordship.
Item
15.
What do you mean some why?
Lordship, he has gone from for CAT, Lordship, for regarding a Mizoram matter, Lordship.
So I am from Mizoram, I am here. Show me item 15. In fact, two of us are from there. So we are more important than some petitioner there. And isn't it?
Here, child is the daughter of the
Hmm.
victim.
PW9.
Yes.
What to do? He's not there. What to do? Aren't you ready?
No, Lordship.
And you have not even submitted any application. You see, the problem is the reason for submitting an application for adjournment is to enable the court not to waste its time. We have read the file. The only question is with regard to prosecution witness number 9.
She has reported 2 related witnesses, 1 independent witness.
But what to do?
My lord, in absence of the counsel.
In the absence of the counsel, we cannot punish the appellant
No.
by, not hearing the appellant. Right. And this is amicus curiae. Next time, if he doesn't come, we are going to appoint somebody else. Please tell him. And he's gone to CAT.
Sorry.
And you have got a matter here in the High Court. Supposing you tell the Supreme Court that the counsel has gone to the High Court and please adjourn the matter, would it be proper?
No.
And this is with regard to liberty of a person. That is just a matter of service matter. Right. Adjournment prayer has been made on behalf of Mr. A. Kalita, done at amicus curiae, on the ground that he has gone to CAT, Guwahati.
Observed there.
Okay, on the ground that he has some personal difficulty. This is the matter. After 2 weeks. Okay.
Obliged.
Here the department has challenged 2 orders passed by the landlord CH. One is of 2015, another is of 2023.
Show us 2015 and
Lordship, page 94. Lordship, here, for going to that order, Lordship, here the question is whether the petition.
94 has been made on the basis of this R. Chandrasekharan.
Yes, sir.
Okay.
Lordship, my humble submission, the part of the order was implemented, but still OA is pending. There was some.
OA is pending.
Yes, Lord. And in the meantime, Lordship, my landlord will also agree. There is a judgment of Honorable Supreme Court, 2023.
Sudesh Kumar.
Yes.
K. Sudesh Kumar.
Yes, Lordship. And
So basically you are saying that this Supreme Court judgment covers this case.
Lordship,
Only thing is that the recovery should not be made. Is it?
My lord, my humble submission is that I paid 2 weeks time to file affidavit. I want to place on record, my lord, the judgment that relied to the Madras Court by the Honorable Tribunal. It is a judgment, it is a repetition after 8 years of that judgment.
Mr. Counsel, that's not the issue.
My lord, I am submitting. My lord, R. Chandrasekharan judgment they have implemented.
They have implemented.
They have
No, but then there has been R.
Similar
Chandrasekharan.
situated.
No.
He has also
Okay, R. Chandrasekharan they have implemented. But this case, K. Sudhish Kumar judgment,
My lord,
now that is on the same lines.
my lord, same line.
Then,
Interpreted clause 8(1) of the, my lord, once my humble submission is that once a judgment and another judgment, my lord, that is what I want to, I take weeks time to file affidavit. Another judgment of the same enforcement department of the Balakrishnan case, Madras High Court, approves the Honorable Supreme Court by the Union of India. Honorable Supreme Court dismissed that
is that R. Chandrasekharan?
another Balakrishnan case, and
Okay.
in our Chandrasekhar case, Balakrishnan has been relied. Which has
Okay.
been reviewed, Supreme Court also dismissed. Because during the intervening period, my lord, 8 years intervening period, many things have happened. A piecemeal basis, they have implemented some of the judgments.
And
And
some they have not.
Judgment, that is why they delayed defeat, my lord. Prospective overruling, my lord, my humble submission is that if I believe,
But they have not implemented your case as on date.
that is what 8 years.
Now, but which is the impugned order you're challenging?
Yes, lordship, there are two orders. One is of 2015,
Sure.
page 40. It's a
Page 14,
40.
40,
Here this OA was allowed on the basis of part Chandrasekhar law.
page,
Page 46,
40.
operative part.
page 40,
Page 46, is the
46,
paragraph 11 law.
paragraph 11.
The similar issue in the case of Art
It's
Chandrasekhar,
allowed in terms of R. Chandrasekharan, but what is the date of the order?
is the order is of 26 June 2020, 2015.
26 June 2015.
Lords-
So now you have not implemented this order.
No, lordship, there is a lordship may come to page 48.
48.
Yes, lordship.
Yes.
It was implemented by the department.
Then if it's implemented, it's implemented.
Not
What
implemented.
remains?
Now
My-
they
my
say,
lord, not implemented.
lordship, what
Huh?
happened? Lordship,
Not implemented. That is what I am submitting, my lord.
Or not implemented?
Not implemented because what their stand is that the tribunal order allowed the OA, allowed the and the prayer order card 6600 based on the judgment of the R. Chandrasekharan. Now they have passed an order denying that the direction of the Honorable Lana Tribunal. Now that is why we are saying that that has not been implemented, and tribunal also not satisfied with the order they have passed. Now that order which impugned in the last annexure, tribunal has reiterated this order, and tribunal has said that this is cannot be implemented because tribunal. That is,
Now, but now they're challenging this order before us.
my lord, my humble submission is that it is basic challenge is the 2015 order because it is in the process of the implementation.
So 2015 order is this page 41 to 47.
My lord, basic challenge is that.
Yes.
That is why tribunal has said you have not challenged the basic order. That is the order of 2015.
2000, which order?
This order, my lord, page 40.
41 to 47 are challenged.
They are not challenged, never challenged.
earlier it was not challenged. Lord.
8
no.
years time,
Acha, this order not challenged.
not 8 years. My lord,
But now they have challenged.
I will, my lord,
Acha, so this order,
my lord.
now you have filed an execution case or what? What is this?
That is a for execution of
He's
this.
filed an
order.
application for
Under rule
implementation of the
under
order.
rule 24.
Okay, implementation of this order.
Yes,
Okay.
lordship, in the meantime, what happened in 2017, we passed a speaking order. In our submission, lordship, that may be incorrect. We have implemented the order.
Implemented this order,
Yes,
Not
40.
implemented.
page 40.
my lordship,
They passed.
Yes, please.
Right.
So, you see, we cannot hear.
as per my humble submission, this order was.
Some businessmen in India during the telephone era, they could put 3 telephones and talk to 3 different persons simultaneously. That's what we saw in the, in the newspaper captions and all.
And it means in one-
Unfortunately, judges, so we are slightly slow in our thinking. We need one person at one time.
Lordship, by order dated 25th of July 2017, the department
25th of
2017.
Ah,
Page 48, annex 4.
page 48.
Lordship may come to page 49. Order.
Yes.
In the light of the ministry's above clarification, it is hereby ordered that the applicant OA is entitled to benefit of NFG on completion of 4-year service in PB number 2 with GP 5,400 with incremental benefit which will be treated as one financial accreditation under MSCP. In view of the above, it is hereby ordered to refix the pay of Sri Sudhanshu Dev, the then superintendent, now assistant commissioner, treating the NGF in payment 2 with GP 5,400 with incremental benefit as one financial accreditation under MSCP scheme. Accordingly, the given answer of petition is false. They are not satisfied with this. Lordship.
So this is not fully in terms of the R. Chandrasekharan and all.
Exactly.
So they have They have not given you that 6,600
No,
great pay.
Yes, Lordship, it was not given to him.
So no, they want only this part. They want
No,
only this
No,
5,400.
Lordship, the now problem is this, in the meantime, judgment of Supreme Court is came, and it is held that under MSCP, they are not entitled to higher pay scale.
He is not claiming that.
Yes, he's claiming that, Lordship.
You're claiming that.
Yes.
my,
Are you claiming that the promotional cost
Yes.
post pay scale of 6,600?
Yes,
my
Lordship.
lord,
But then this order does not give them that.
Yes, this order is not given that.
This the order does not give you that.
In the meantime, what happened? They filed an application for implementation order, we come for objection, and this order was passed. Now they are claiming that this order dated 25th of July 2017 is to be set aside.
25th July 2017.
Yes,
Acha.
I placed before you.
Acha, this one there. Where is the date?
Lordship, page 50.
Page 50. Okay.
Now by filing MA, they want to, they are seeking to set aside this order.
Okay.
And in
Okay.
the meantime, Lordship, rightly, wrongly.
Because they want implementation of this order
Yes, sir.
at page 40.
Yes,
So according to you, in view of page 40, page 48 was issued,
yes,
whereby you have given pay band up till 5,400. You have not given 6,600,
yes, sir.
but they are claiming 6,600 in terms of R. Chandrasekharan's
Yes, sir.
judgment.
Lordship, now, Lordship, question before you, Lordship, around. When there is a judgment of Supreme Court explaining all these things, whether we can implement, whether we can given.
Now, where is the misapplication that they have filed?
Lordship,
51.
no, Lordship. Page 69, Lordship. Lordship, prayer is that,
Just a minute. 69.
page 91, Lordship, prayer in the case.
69 it starts.
Yes, it starts 69.
Mr. Counsel, this is a reply of the applicant.
No, Lordship,
Where is the main application?
no, Lordship, main application that prayer is not there.
A prayer is not there. Right.
Page 51.
Ah.
Page 51, simply their contention was there because it was filed before that order was implemented. So,
To implement the judgment. Okay, out here only to implement the
yes,
judgment.
this is our contention. Lordship, now Lordship come to page 91.
Yes,
Page 91,
yes.
prayer. In the facts and circumstances, the Honorable Tribunal be pleased to set aside was the order dated 25/7/2017 passed by the Chief Commissioner and further be pleased to proceed with the pending execution petition and be pleased to order implementation of judgment dated 26/6/2015 with reflection
Now,
of pay.
now you see, why don't you take this, since the cat is already is already looking after this matter and it's already there, why don't you take this aspect to the
Lordship,
cat and inform them?
we took this, we placed before this judgment, but the learned tribunal observed because this is a subsequent development. First, we have to implement. That's why, Lordship, we have compelled.
Where is that order of the
Lordship.
tribunal?
Page 9, annexure 9, page 94.
Okay. Where?
Lordship, may come to page 95 order.
Yes.
In the light of the ministry's above clarification introduced by order that the applicant OA is entitled to benefit of, and that way we have, that is quoted from our order, Lord. Then paragraph 3, as per respondent, since subsequent DOPT letter dated was withdrawn, but letter dated 26/2016, therefore applicant is,
Wait, where are you reading?
then page 96. Lord.
Yes.
From the perusal of the above, it is noted that the applicant was initially in pay band 2 with grade pay of 5,400 and subsequently he was granted PB 3 with grade pay of 6,600. Therefore, since this tribunal has already directed extension of benefit in terms of the Honorable Madras High Court case of
Oh.
R. Chandrasekharan, and since the respondent have been referred, never preferred any appeal against the same, therefore, they have no authority to interpret or take care of subsequent circulars of DOPT pass any order. In view of the above, we are not satisfied with the submission made by the learned counsel for the respondent as well as the respondent's order dated
Okay, got it.
25/7/2017.
Okay.
This is the case. So, Lordship, the question whether we can in regulation of the Supreme Court direction, whether now we can implement Lordship. This is a question before your Lordship.
My humble submission is that my lord, arts and the secondary judgment they have implemented. They are silent about the implementation of their judgment. And during the intervening period of 8 years, the repetition has been filed.
I think you have to go to Supreme Court to clarify this.
That's my
Because
lord,
this,
after it is. Let me,
because this case Sudesh Kumar has clarified this issue.
I humble submission is that I want to pay, file an affidavit which can be granted. I want to place the judgment, other judgment also, which the Supreme Court has upheld. And because this, during this, and on the law of the prospective offer. I want to.
It will-
And to file
Okay, we will allow you, but we'll stay this order.
my, that is,
Further proceeding.
because 8 years they have not.
Further proceedings will stay. All proceedings will stay.
And after 8 years, Honorable Supreme Court has said, writ petition maximum 4 to 5 years. You cannot repay a Kumbhakarna decision, 14 Supreme Court has said, my lord. After 8 years, how they can approve?
Why not?
Supreme Court has said, my lord.
Why not?
You are,
To implement a judgment of the apex court, why not? Because the judgment of the apex court is the law of the land.
Yes.
If there is some other rulings made by a tribunal or a high court, which is not in conformity with the judgment of the Supreme Court, should we continue to follow the judgments which have been reversed by the Supreme Court and held to be incorrect law?
my lord, some of
Should
the-
we say that something that is not held to be correct should continue to be followed by by us?
this.
How can we perpetuate an illegality?
Supreme Court has,
No case, Mr. Counselor. Only out of, we want to be clear in our final order. That's why we're giving you a chance.
my lord,
That's
I will
all.
place some.
Otherwise, prima facie, no case. Yeah, prima facie got a case. Okay, right. Heard Mr. S.C. Care, learned counsel for the petitioners. And Mr.
Yes, not.
S. Nath, the appearing for the cavator / respondent. Pustak. The petitioners have put to challenge the order dated. No, have paid for setting aside. I'm so used to that criminal case dictation. Have paid for setting aside the order dated 26/6/2015 and the order dated 20/2/2023 passed by the Central Administrative Tribunal, Guwahati Bench. Bracket circuit sitting at Impal. No, just a Guwahati Bench
Earlier, Lord.
in OA number 040/00416 of 2014. Acha, you say that this, huh? Order dated 26/6/2015 in 040/00416 of 2014 and the order dated 20/02/23 passed in
MA.
MA/180/2016. Full stop. The petitioners counsel submits that in terms of the order dated 26/6/2015 passed in OA 040/00416 of 2014, comma. The respondents were directed to grant non-functional GP, non-functional GP grade pay of rupees 5,400 under PB-2 with effect from with effect from 1/1/2006 and thereafter. Second ACP with grade pay of rupees 5,400 in PB-3 on completion of 24 years of service. Full stop. Besides the above, the petitioner, no, the respondents were also directed to, the petitioners were also directed to grant the third financial upgradation with GP of rupees 6,600 in PB-3, Roman 3. Also. On the basis of the order dated 26/6/2015 had been passed in line with the judgment of the Honorable High Court of Madras in the case of R. Chandrasekharan in Union of India and others versus Shri R. Chandrasekharan, WP number 19024 of 2014 and MP number 1 of 2014, page 43. The petitioners in persons, the petitioners in persons to the order dated 26/6/2015 passed in OA number 040/00416 of 2014. Thereafter passed the order dated 25/7/2017, whereby it was ordered to refix the pay of the respondent, treating the NFG in PB-2 with GP of rupees 5,400 with incremental benefit as one financial upgradation under MACP scheme. So, page 49, last paragraph. Being aggrieved, next paragraph, being aggrieved with the order dated 25/7/2017 issued by the petitioners, the respondent filed MA 180/2016 for praying for implementation of the order dated 26/6/2015 passed in OA number 416/2014. In as much as the respondent had not been granted PB-3 with grade pay of rupees 6,600. Next paragraph. The learned counsel for the petitioner submits that though R. Chandrasekharan's case, Supra, had been followed in some cases by the petitioners with respect to some individuals, the respondent herein had not been granted PB-3 with grade pay of rupees 6,600. He submits that subsequent to the above, he submits that prior to MA 180/2016, being being filed by the respondent, the Supreme Court in the case of Director, Directorate of Enforcement and another versus K. Sudhish Kumar and others reported in 2022 3 SCC 649 has held that the High Court has no jurisdiction to interfere with the government policy in the form of ACP scheme, which was made after accepting the Sixth Central Pay Commission. Full stop. It thus held that the High Court had committed a grave error in allowing the grade pay of rupees 6,600, that is the grade pay which was available to the next promotional post. Full stop. Next promotional post as deputy director. As deputy director. Full stop. Next para. The petitioner's counsel submits that the R. Chandrasekharan is covered, R. Chandrasekharan Supra is covered by the judgment of K. Sudhish Kumar Supra, as the fact situation and the issues therein are the same. Full stop. He accordingly submits that the order dated 20/02/23 passed by CAT Guwahati in MA 180/2016 has to be set aside, as no order can be passed beyond the law laid down by the Supreme Court. Full stop. Next, Mr. M. Chanda,
Yes, not.
Mr. Esnath, learned counsel for the cavator / respondent submits that the judgment of the Supreme Court in K. Sudhish Kumar Supra would only have prospective effect, and as the right of the petitioner to be given PB-3 in the grade pay of rupees 6,600 had already crystallized in the year 2016 when
15.
OA number
2015.
416 is it?
416,
416 of 2015, 2013,
14,
2014
14.
had been disposed of. Full stop. The said judgment would not be applicable to him. Full stop. He accordingly submits that he needs some time to submit citations in support of his submissions. Full stop. In view of the above, Mr. Esnath is given 2 weeks time to produce citation in support of his submissions. Full stop. This is the matter. After 2 weeks, in the interim, the order dated 20/02/23 passed by CAT Guwahati in MA 180/2016 shall remain state, and no further proceedings shall take place. Shall be taken in MA 180/2016 till final disposal of this case.
Okay.
Then you write, in view of Mr. Esnath appearing for the caveat, the caveat stands discharged.
Much obliged.
While 302 case law appeal,
Yes. Okay. Third, Mr. R.P. Sharma, senior counsel appearing for the appellant,
yes,
who submits that the impugned judgment
yes,
dated 13/6/2023 and the sentence dated, and the sentence order dated 15/6/2023 passed by the Court of the Sessions Judge, Lakhimpur at North Lakhimpur in Sessions Case number 160 bracket NL /2017, by which the appellant has been convicted under section 302 IPC should be set aside. Admit the appeal, call for the LCR. Ms. El Jahan appears for the state, additional PP appears for the state. List the matter after,
IA is there.
after 4 weeks. After 4 weeks.
Let the IA pending my let the record come, then only your.
No, let her file her written objection. Ms. El Jahan, additional PP is granted 4 weeks' time to file written objection to the application made under section. No, this is not under 389.
No, not three.
It's application for bail only.
Yes.
Branch of bail, suspension of sentence, he has not prayed
He
anywhere.
has not paid.
Prayer like one for suspension of sentence under 389.
You have to, yeah, you have to make you make a fresh application.
Anyway,
You're not paying for,
let the records come. And
No,
let
no.
her-
what I'm saying is, you see, if you are going to ask for suspension of sentence,
Yes.
then the 389 application will have to be made. You have not made a, so in the meantime, you can do it.
Let me take, my lord taking to be 389.
It cannot be, sorry, it cannot be. You see, what has happened is, we had a meeting the other day. Now, we used to allow correction in the code by hand. Now, what is happening is, the CIS does not recognize that. The system, it cannot be uploaded in the system. So now the notification has been issued by the High Court that wherever an amendment is to be made, even a correction, that application has to be submitted by you for amending. We will allow the amendment, and then you'll have to submit a fresh application, and that will be uploaded in the CIS.
Okay.
So we cannot allow you to make the correction by hand.
The pleading parties.
Yes,
need
we used
do
to
it
do all that. That we used to
by
do.
hand.
The other day also, but then it was
Uh,
not allowed anymore. My stenos
Yes.
had, sir, what have you done? Okay, sorry, I made a mistake. So it happens. So
Yes.
that's
So,
why
since this application cannot be considered this.
you withdraw this,
Yes, so I will.
you withdraw this. And with liberty to file afresh if you want, because in any event, you'll have to make an application for amendment, then file the,
No,
takes too much time. Okay, right. Mr. R.P. Sharma, learned senior counsel, prays that he may be allowed to withdraw the IA with liberty to file afresh. Ms. S. Jahan, additional PP appears for the state and submits that she has no objection to the same. Accordingly, the IA is disposed of as withdrawn, dismissed as withdrawn, with liberty to file afresh.
Record I will call for one.
Yes, in the main appeal.
We have record in the main appeal.
Procedure is rightly followed here. I mean, the sentencing is on a different date and the.
Yes,
judgment
yes,
on it.
yes.
There is,
Procedure is rightly followed in this case.
that is,
Yes.
there already. Your lordship was not ready.
Lokhimpur.
So PB is here.
My lord,
Paper
no,
book?
I have not received the PV. My lord, lordship will see that order dated 3/4/23. There is the direction to the registry to for rectification of the paper book. And I have not received.
Paper book has been rectified
Oh.
as per this 28/4 office note. Paper book has been rectified and furnished to Ms. B. Buyan, learned additional public prosecutor. Office note, madam. Signed by Benju Moni Daimari, judicial assistant, on 28 April,
It was 18 April.
28 April.
Signed by? Signed by.
For PP, this someone M. Sarma has signed.
Oh, our office, my lord. Always, your lordship.
It
It
is
receives
served,
it and misplaces it.
But
And
what to
it's-
do? They have to give, they can't keep on running after you. You might be in the canteen, you might be
No,
somewhere in the mall.
We sit here and
And
the
to-
criminal court.
They
And
cannot
today
give you,
they have not sent the copy.
They should provide us, my lord.
that is your office, you ask from
Our
your
office,
office.
yes,
That is your office problem.
Yes, yes.
We cannot look after the problems of your office.
But the amicus is,
Not given. Okay, who are the amicus? Mr.
Yeah, I mean-
Bhagwati,
I mean,
Kalita and Edar. All of you. Okay.
I mean, I don't know full lordship and half of the page is lordship upside down lordship. In the paper,
So you correct that upside down portion. What is that? What?
they may be there to provide it.
Arre, look, if it's upside down, you just take it out and you just put it
Right.
in the correct
Yes.
manner. And then you have got, you see earlier what we used to do, is to make that hole and then stitch it up. That's how you do that. What is so difficult? What about you?
Item number 4, lordship, now I had a follow number, lordship. In that case, lordship.
Both of them are appearing. Oh, both of them are appearing for court.
I am appearing as amicus curiae.
Oh, acha.
He has engaged privately.
I guess that.
So,
I had 2 applications. One is for under section 339 for suspension and another is for 391 for taking additional evidence lodged during epilepsy. Because the thing is that lodged, the person, this appellant, he was a minor at the time of commission of the offense. So he took the plea in that at the time of commission of this case also. However, lodged the Lanes Commission Magistrate lodged. He lodged did not take consider that aspect lodged and even after lodged, according to the statement of the headmaster, when lodged this person studied, he did not consider that aspect also and accordingly. Straight away lordship, he was sent for testing trial before a session. So the
IAs
mistake
are not
was-
here.
I have had 2 IAs.
Recorded nahi.
Oh,
That has not
acha.
come in the
Huh?
records.
where are the IA?
Not
Yes, sir,
listed.
I have had those. Yes,
Yeah,
sir.
filed yesterday. Let it come.
Yeah,
That will come.
You are talking about something. Hey, there's a mango tree. Mangoes are going to come. They're going to grow there. You wait.
Let it come.
Let the mangoes come. Then we'll think about eating it, plucking it, whatever. Out here, the eye is not here.
Let the IA come.
Yes, they will come. So then, you have got. Then who is for 5?
I'm in 5.
The brother is for 5 lords. I am
You are
for
in
4.
5. And who's for 3? Bhagawati.
Bhagavati.
People who are
He
going
comes
not
in.
there.
Has
He
he got?
appears.
The question is, has he
Ah.
got the paper book?
Where will be Bhagavati?
Okay, right. Mr. B. Bhagawati, learned amicus curiae in criminal AJ 31/2022 is absent. Mr. J. Kalita, learned amicus curiae in,
He
Ah,
has been
sorry.
engaged privately.
Mr. N. Hassan, learned amicus curiae in criminal AJ 32/2022. Submits that he has received a copy of the paper. First stop. Mr. Edhar, learned amicus curiae in criminal AJ 34/22 submits that he has not received a copy of the paper book. Is there any additional copy? Just see, we can give you straight away. No. Full stop. Accordingly, a registry to give a copy of the paper book to Mr. Edhar, learned amicus curiae, and also make a report as to whether Mr. B. Bhagawati has been given a copy of the paper book. List the matter for hearing in usual course.
Lordship, this IA, since I have had the IA, lordship, no come with
Oh, I with regard to the with
item number 4, lordship.
Juvenility.
Can be taken up next week. I.
Next week, lordship.
if
This is
at
the
all he is
matter-
juvenile,
huh?
then.
list the matter in the next week.
Please, lordship.
CR has arrived.
LCR is here, only paper book needs to be prepared.
Okay, right.
Miss Bonali Chaudhary otherwise comes today.
Just
She
that
was-
as LCR has arrived, registry to prepare the paper book. This is the matter after 6 weeks. So paper book is there.
Yes.
Now, so what do you want? You want to argue on the IA?
Yes, actually, sir, I just want to, hearing of I petition.
Okay.
This is that matter where council has come
Yes,
from
I
Calcutta.
am coming from.
Oh, you're from
Calcutta.
Calcutta.
Yes, sir.
This is POCSO
Yes, Foxon account.
4-2. Yes, so what is your case?
Sir, I'm just going through some.
Yeah, please, your Lordship, Lordship, the office note says that the AD cards have not been received back, Lordship. May I pray, Lordship, I will take fresh steps in. Alternatively, I may be allowed to take steps by Dusty because the trial is going on. I will be able to serve him there.
So you'll take fresh steps?
I'll
Or
take
what?
fresh steps and along with Dusty, Lordship. if permitted.
Okay, right. Third, Mr. RKD Chaudhary. Leonard, Deputy SGI. As per office note. No unserved notice or AD card has been received back from the respondent number 2. What about 1?
One also, there's no report on one.
There's no room. For the respondent number 2. Full stop. There is also no report with respect to respondent number 1. Full stop. In that view of the matter, the learned counsel for the applicant is allowed to take fresh steps for service of notice upon the respondents 1 and 2.
Along with Dusty, Lordship.
This will be the third time, I think. No?
So, previously it has gone by post, but I see this, this is, I guess, rejection, this is, I guess, granting of bail. So therefore, Lordship, the trial is on.
No.
So I can have it served in
Yes,
the.
yes. So you just say, just say Dusty will do, I think.
Yes,
So what have I said? No, don't say that. In view of what, just carry on, in that way the matter. By way of Dusty service. So it is allowed to serve notice, upon the respondents number 1 and 2 by way of Dusty service as the trial of the case is still going on before the special court. NIA. List the matter after. When do you want? You give a date.
let it be after 4 weeks, I do not.
List the matter after 4.
May I plead your. It's just for service of notice upon respondent number 2. Has been taken. On perusal of office note, I found that LCR has not been prepared. We are required to wait till.
What?
LCR has not been arrived.
That's right. So what about respondent number 2?
Respondent number 2 is Syed Ali.
No answer, no ID card. Then what to do?
So he's the eyewitness.
Huh?
Eyewitness.
What?
He is the eyewitness in this PW1.
So what to do?
So
The
we are
respondent number
required to wait till the arrival of LCR. It's a new date. Kindly.
There is no return of AD card from the respondent number 2. So what to do? Do you take fresh steps or what? Do you understand what I'm saying?
I also come to know that ADA has not arrived.
So,
So
you're echoing what I'm saying.
actually, I want to take a fresh step.
Who's your senior?
SR Gala.
Tell him to come next time.
Yes.
And otherwise, you're not understanding the questions put to you.
Okay.
What is your name?
Yeah, there you go.
Mr. P. Hazarika. Learned counsel for the appellant. Are you the appellant? Are you the counsel?
Yes.
Okay. We'll take fresh steps for service of notice upon the respondent number 2 by registered post with AD within 3 days. As there is no return of unserved notice or AD card in respect of the earlier notice issued to the respondent number. This is a matter of 4 weeks.
Obliged.
My lord, please, my lord, petitioner, my lord, before your lordship is wife, my lord of the respondent. My lord, the respondent file, my lord, one divorce case, my lord,
Divorce case.
my lord.
Wife
Yes, my
filed
lord,
divorce case. Wife is the respondent.
Wife, I am petitioner, my lord, wife.
Yeah, the sciatica is basically everyone has sciatica.
Yes.
That is basically your L4, L5, that
Ah.
pain radiates down
Yes.
to from here to your toes.
That's
That-
not very serious, my lord, but if your lordship
Mm.
comes to page 19 of my application,
Yes,
or page 18, rather page 18 of my
Yes.
application. My lord, this is of 4th July 2023. I have visited the Morigaon Civil Hospital and I was undergone a CT scan. Page
Mm.
19 is the
Yes.
CT scan. My lord, last line, impression.
Hmm.
Chronic lacunar infarct in right insular region.
yes.
Now, if your lordship takes up my paper that I said,
Hmm.
point number 1A, chronic infarct, lacunar infarct in right insular region. An infarct or an ischemic stroke occurs when the blood supply to part of the brain is interrupted or reduced, preventing brain tissue from getting oxygen nutrients. It has significant morbidity and mortality. It can lead to significant physical and cognitive disabilities. My lordship, that footnote I have given from where this I have got this. Then second page, my lord, age-related diffuse cerebral and cerebellar entropy with small vessel ischemic changes. This is the second 1B, which says an entropy refers to a loss of nerve cells and neurons and a connection that help them communicate with brain tissue. Occurs in many disorders that affect the brain, such as stroke. It can sometimes lead to shrinking of brain. Now that's what dementia comes in.
So
Right.
it happens to everyone.
My lord,
Most people.
75-year-old person. Third point, my lord, hypodense area in right parietal lobe. That is 1C, which means term acute infarct refers to a recent ischemic stroke, means a high stroke which occurs because of high blood pressure. I was given bail because my blood pressure was above 220. That was the only reason for giving me bail, and I was a 75-year-old person. Now, what I'm suggesting, my lord, let him be on interim bail for some more time, because already his 2 sons are in jail for the same.
You see, the last order passed by us.
Yes, my lord.
The last
6.
order passed by us says that the application shall surrender before the concerned jail account. You surrender, then you file a fresh application.
My lord, he is bedridden actually.
No,
He
there's
is
no.
bedridden.
I don't believe.
If your lordship comes to later part, later.
Yeah, let us see let us see what is this.
If your lordship comes to.
Senile dementia and lumbago sciatica.
My lord,
Okay,
page
then-
24. That is at page 24.
I know. Then what have you been given?
Well, I have been diagnosed by the, and I was said I will come to
Medicines are at
PHCH.
play,
Medicines
page
have been given,
26.
but his condition is
Medicines
not.
are at page 16. The
26 also.
Pantocid is again
Those
stomach.
medicines are normal, my lord.
Then
Those medicines are normal. Page 19 and 20, what I am suggesting, my lord, page 19 and 20 says that the stroke, that this things, the chronic lacunar infarct and age-related cerebral entropy, these are all reasons because of high blood pressure. These are minor strokes that have happened, occurred to me.
I don't know if your documents are, why didn't you go to,
My lord, this is Morigaon Civil Hospital.
why didn't you go to GMCH? This could be fabricated.
I
That
cannot
was
travel.
advised.
Huh?
That was advised, but I cannot travel. That is the biggest problem. I'm not able to travel.
You see, you come to page 24.
Yes, my lord, I have been referred to GMCH,
You
I've been
come
referred
to,
to
you
GMC.
come to page 24. You see the date,
11/7.
11/7/23. This is a advice slip given by Dr. Arun Kumar Nath on 11/7/23. And he says that he has been suffering from senile dementia. First of all, doctor doesn't know how to spell dementia. I don't know. It should be D.
But it's the typed
Type
version.
copy,
Anyway,
original one. I think it's
Original one also shows
DI.
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 No, this is also, I don't know if this is a fabricated document.
It's a civil hospital document, my lord.
No, I don't know, that
He is the
because,
superintendent of civil hospital, Morigaon.
okay, now you come to page 28. Same doctor
Same doctor.
giving another advice slip on the same date.
Yes, my lord. He has
What do you
given
mean,
us- My
yes?
lord, just for two more months, I'll try to bring him to GMCH or for private treatment and will produce the records.
Oh, different. Advice slip is different. Advice slip is not the same.
Yes.
My lord, it's of the same date. It's of the same date.
Two advice slips on two different.
I don't know,
slips.
my lord, but
To advise live on the
but
same
if your lordship
days.
comes to the CT scan, that has been taken care of. That has been gone into. CT scan makes things apparent. CT scan is done in the Morigaon Civil Hospital.
Same number, everything, same number, OPD registration, same number, same date.
Petitioner, patient registration will be same number, my lord. Number.
No
will be
one
same.
no one gives two advices like this.
What I'm asking, my lord, let me be on interim bail.
And then now you come to the dates, page 25 and page 29. 25 and 29 in handwriting. Just see. And you see how two is written in 25 and how two is written in 29. Different, not the same person.
My lord can call a report from the superintendent then from Morigaon Civil Hospital.
So
Because this is a government hospital.
we will dismiss this, you file afresh.
My lord, what I'm saying, I mean, asking for interim bail, not permanent bail. Give me another 2 more months. I'll try to
You,
come to GMCH.
you file afresh. We do not believe with the authenticity of this document.
Two advice slip on the same day is bizarre.
Yeah, bizarre, very bizarre. Not only that, if you look at 24, 25 and 29,
Yes.
the writing two itself, just two is also different.
Hmm.
1, 2,
My
1,
lord,
2,
what
3.
I would say,
The date
what I would
comes
say, the earlier portion, it's filled up by the peons. Only the certificate is written by the authority or the doctor who is examining me.
We don't know, Mr. Counsel.
It's a government hospital. What can I do, my lord? It's a government hospital. It's not, had it been for a private hospital, I would say it's, yes, but it's a government hospital. If I go to jail tomorrow and if something happens to me, this is the same hospital where I'll be brought. What I'm suggesting, my lord, give me another two months time interim bail. Let me,
You file a fresh application, we'll see. This order already there. You file a fresh, we'll see.
He was supposed to surrender on
it will be
When?
6th, it will be 6th
6th
August, I'll have
of-
to surrender.
August.
2 months from the date of my release. So that ends on
In the meantime, you file another one. 6th you surrender and 7th you can file.
My lord, I'm just seeking for interim bail for another 2 months, not
Maybe. Mr.
just extending my bail. That's all. Your lordship.
You see, the problem is when some things don't seem right, then our thinking goes slightly, on
I
a
understand,
different
my lord.
tangent.
I understand, but these are government hospitals that
No.
the documents have been taken from them. Lordship can call for a report then.
Mr. Counsel, the
Another reason we are sent to government hospital is that.
Two advice on the same date.
This is.
I understand, madam, whatever document has been given to me by the patient's father, the son, I have annexed it. If your lordship has some doubt that a report can be called from the superintendent, this is the same, this is a government hospital, my lord. Every prisoner of Morigaon jail will be taken there if something happens. So every document will become. To be have to be questioned.
Maybe the son is over smart.
No, my lord, the poor people. Two.
Poor people who is eligible, who can have two advice slips from the superintendent, mind you, not from the doctor, from the superintendent of a civil hospital, a poor person. I doubt.
My lord, I would say this person, Rajeshwar Bodloy, his condition was taken up by even the Asalsa. There was a jail visit conducted on 30th of April, where the portfolio judge has even gone. And it was suggested that if nothing happens, file a writ petition for his shifting to some other hospital. Because Morigaon jail does not have.
Where is that? Where is that? Where is that?
My lord, the jail report.
No, where is that portfolio judges?
There's a jail visit conducted with the Asalsa by an NGO. That report is, I can pass on the report, my lord. I can pass on the report. It is with me. I can pass on the report.
Sure.
My lord. My lord, the district judge, the CJM, everyone was present. Oh, soft copy of this one. Where was it? Do we have it? Yes. My lord, page 6. Your lordship comes to page 7, it makes very clear. Highlighted person. Honorable Judge suggested that the MNHOI of District Jail Morigaon should be replaced to ensure that the rights of inmates to adequate medical care, which is an extension of their right to health and guaranteed under Article 21, should not be infringed. Due to such administrative lapses. My lord, my CT scan report that I cannot that I have not manipulated, if at all the others. CT scan report says certain, I am suffering from certain.
Once we have a doubt with regard to your document, there's no reason why we should not doubt the others.
Exactly, my lord, that's what I'm saying.
Exactly, that's why we might
My
have
lord,
to,
see,
cancel.
this has been done in a civil hospital. My lord will call a report from them, whether it's
No.
true or not,
We'll see,
because I
we'll
cannot.
take it up at.
Not true.
F2.
Something don't look right, that's the problem.
Whatever has
It
been
is
provided by
their
the hospital.
application.
Huh?
It is their application. They
Their
should come with
application.
clean hands. Now
Yes,
here.
that's all. Only-
lordship
only-
has sealed.
It is
That's
not.
one thing I don't like.
My lord, what I'm suggesting, I have come with the documents given to me by a government hospital. It is not a private hospital. It's a government hospital.
Maybe.
Then the superintendent should be dismissed from
Maybe,
service.
maybe.
In fact, the online address, anybody can be, if any government official can get it from there. My CT scan is done in Morigaon Civil Hospital. This states are about certain irregularities in my body. I am just asking for at least 2 months extension so that I can come to GMCH. That is the biggest problem. I cannot travel. And my lord, the certificates, this page number 22, sorry, 25 and 29, these are, my lord, given by superintendent of the district hospital. These are government gazetted government servant.
Look, you have been advised on 11 July.
My lord,
Now more than 3 weeks have gone.
I understand, my lord, this is what my instruction from his son, who has been pursuing this matter, is that he is still bedridden, he cannot travel. That is the
Ambulance is
biggest
there,
problem.
ambulance is there.
That is the biggest problem, my lord. He's not able to travel.
How? Why?
My lord,
Why?
because
Lumbar sciatica, what is this? This is nothing great.
he cannot get up properly.
Oh,
Sciatica.
Mr.
That is what I've been told, my lord.
Mr.
What I'm
Counsel, you see, I know a lot about this. Because I was in Delhi for 3 weeks. I had herniation of L4, L5, S1. So I know about these aspects. And I know, and I couldn't get up. But then I somehow went in a wheelchair, airport in Delhi also wheelchair, so and so. It's not that you cannot
I
do it, it
understand,
can
my
be
lord.
done. So,
understand.
and no, just listen. So the thing is that you are not sitting, you are sleeping in an ambulance. So, and this is only a lumbago sciatica. It is basically the nerves that come and it radiates down to your toes. That pain is there from your back. It is the same thing. It's basically because of herniation of the spinal disc.
My lord, this lumbago sciatica is not the main problem. Main problem is the sheet that I gave, point number A, B, and C, 1 ABC. That's related to my brain. That indicates I had a minor stroke.
So,
That's what I'm saying, my lord. I am not asking for permanent bed. I am not asking for that. I
no,
just want
Mr.
an
Counsel,
extension.
please understand that when you see, when you say you cannot travel, that is something that is not believable at all. Because you can always go in ambulance.
If your lordship comes to page 10, why I was given bail, page 10.
Hmm.
Page 10, my lord, third paragraph.
Yes,
Down below, my lord, down
Yes.
below. Today, when the matter is called up, learned APP has furnished a medical report issued by the District Medical Jail Hospital, Morigaon, dated so-and-so, stating accused, namely so-and-so, is suffering from high blood pressure, continuous headache on left side, migraine, mild chest pain, and both knee joint. Applicant was referred to MCH and GMCH for proper diet, better treatment. Applicant is presently undergoing supervision of the jail. Now, my lord, this headache, this thing, this CT scan says that it's related to a minor stroke.
And
That
that
is
stroke
the
part
issue.
is not there.
It is, there, my lord, that is what I have given.
no,
my
no,
lord.
that tract is, it might turn into a
Ah,
stroke
yeah,
and that's
Turn
all.
into.
I
Turn
have
into a
That
stroke
we
vessel,
always
yes.
say, yes.
I have given the.
No, no, Mr. Counsel, look.
My lord, I am
look,
not asking for bail. my
No,
lord.
no, I'm not saying that. What I'm saying is a person who has had stroke, in fact, who has had severe head injuries, they are taken to hospital, they are shifted from one hospital to the other. And stroke also they are shifted, okay? And I know a lot about this because my father died and he was in the hospital for more than a month. And I know that it can be done, not that it cannot be done. And this track is this, I'm very, the thing is that you're not attempting to go to thing.
No, that's not my, that's
Yeah.
what I'm saying, my lord. Give me another.
Are you,
another some more time.
are you in the hospital?
No, my.
You are
I'm
not in the hospital.
I'm not in hospital.
You're
I'm-
then,
I'm just
you're not
asking,
even in the
give me
hospital.
some time.
It's the same.
He
What
has
do you-
not
He's not
taken
even
it
in
to
the
a
hospital.
GMCH
And he
hospital.
cannot go to a GMC.
I have taken him to, sorry, Morigaon Civil Hospital. MCH.
Mr. Council, I tell you, those who are with severe problems, stroke, they cannot, they needed to be treated in the hospital. Fully, 24 hours, and you thought you're at home. It's
That's what I'm
not
saying,
as
my lord.
serious as you think that you're saying. So,
Just give me. I'm just
unfortunately
asking
for you.
Interim bail for some more time. I'm asking for interim bail, my lord. I'm not asking full and final bail. I'm just asking for interim bail, although I have paid for 4 months, let it be for 1 month, let me somehow come to GMCH. Or my lord will keep this pending, I'll come up with, give me 1 month's time. If I'm able to come to GMCH, I'll produce fresh documents. On the basis of that, this petition may be decided. This matter may be kept pending till then.
We will give you 2 weeks time. You go there. If you don't, we'll close it.
My
Due
humble
to weeks' time.
submission is that
Yeah.
on the basis of two different advice slips,
Correct.
same handwriting,
That's
same
not,
date.
that's not,
That I
this
have-
is,
that I have one
this appears to be fabricated.
This appears to be fabricated.
My lord,
and
I will suggest then that my lord comes to page at, so that this top part is written by generally the peons. Why? Because why I'll say this, my lord, if your lordship comes to page 25.
No, anyway, we'll just give him some time to go. Though we'll keep it pending, we'll decide this at the later stage. Because one thing is that I know who can travel, not travel with this
Madam,
type of injuries.
We are supposed to surrender on 6th. It was from the date of our release, 2 months from the date of our release.
Correct,
That ends on 6th
Yes.
of August.
correct.
This matter may be kept on 25th.
No, nothing like that. This we will take it up on 17th. By 17th you go. Today is the 2nd, you've got 2 weeks to go. You've got 2 weeks to go to the GMC.
GMCH.
Hmm.
If they do not go.
If they do
then
not go and you bring the report by then,
My lord.
you bring the report. If no report, then you go in. If there is some report in which shows that you are seriously ill, then we will see.
My lord.
Right. Heard Mr. D.K. Bhattacharya, learned counsel for the applicant, who submits that on the basis of the medical examination done on the applicant and the advice slips and the two advice slips dated 11/7/2023 issued by the same doctor,
Superintendent, civil.
by the same doctor,
Same
My lord, my lord.
issued by the same doctor. The petitioner needs to be examined in the GMCH. Full stop. Accordingly placed that the bail, the interim bail may be extended for a month. Full stop. Ms. El Jahan, additional PP, on the other hand, submits that it is surprising that the superintendent, it's surprising that the doctor could have issued two advice slips on the same date, which are not similar. Full stop. He submits that as there is nothing to show that the patient, that the applicant is in hospital, no case for extension of the bail has been made out. Next para. We find that the applicant is not in the hospital, though the though the medical, though the medical reports indicate that the petitioner is having some medical problem. The above being said, we are also surprised with the fact that two advice slips have been issued on the same date by the same doctor against the same patient, which are different. Full stop. Be that as it may, comma. As one of the advice slips has advised the petitioner to. It's an applicant, not petitioner, applicant to. Has been advised to go to GMCH for better investigation and treatment. Comma. The interim bail is extended only up till 17/8/2023, comma, on which date the applicant shall surrender before the concerned jail authorities. Only till 16th, only till 16th. No, only till 16th. And the applicant shall surrender on 17th. 8/2023 before the concerned jail authority. Full stop. It is expected that the petitioner shall go to GMCH for better investigation and treatment, and the report therein should be submitted, should positively be submitted on the next date. List the matter
And
On
then
17.
on
17th.
17th.
17th, the matter may be listed. If it is.
List the
dismissed-
matter on 16th. List the matter on 17th. List the
If it
matter
is
on 17th.
dismissed, then I'll surrender.
List the matter on 17th.
And I'll-
16th.
I'll have to surrender before then it is listed.
Huh?
My lord, the order would say that I have to surrender on 16 and the matter will be.
No, no, you're
17th.
17th, 17th.
Ah.
Your bail is still 16th. And 17th is your surrender date.
And this is
16th.
matter is listed on 17th.
16th.
17th.
17th. Rather than my lord, if the bail is rejected that day, I'll anyway have to surrender. My surrender on 17th may not be required as of now.
No, matter will come up on.
Matter will anyway come up on 17th. If your lordship takes up those reports and decides or feels that I may be allowed to stay on bail, then what is the reason for me to surrender on 17th itself? If the bail application is dismissed, I will anyway have to
No, no,
surrender.
we're done. We're past the order. Will really remain like that.
But then-
If your bail is extended or bail is allowed, then we'll pass the order.
Doesn't have to
Similarly-
surrender then.
Then have to surrender. Similarly here also.
He doesn't have to surrender till the matter is taken up here. On 17th.
Obliged.
Which one? Which one? In your case. Okay, paper book is not prepared.
I'm not.
Record has come on. Record has come, then in the main appeal, you right? Huh? That 2 weeks time, then it's okay, they're paid 2 weeks time.
Main
Okay.
appeal, LCR is here. Let the
LCR,
paper
no,
print.
just write,
Paper-
just write in the main appeal, you write. Office note indicates that 2 weeks note is required. 2 weeks time is required for completion of the paper book. Full stop. This is the matter. After 2 weeks.
17th.
This is the matter of 70.
Obliged.
Hey, please, your lordship. Establish prefer from jail lordship by the appellant against the order of conviction under section 302.
Yes,
Lordship. In this case, the appellant is alleged to have committed the murder of his younger brother.
younger brother, difficult case.
Difficult lordship. And to be honest,
Eyewitness is there.
no eyewitness is there.
Not eyewitness, but I mean, it's seen running out,
Yes, yes, lordship.
seen running, and then oral die declaration is there.
Oral, one line was lordship to his wife before dying. That is lordship.
Extrajudicial also, PW3.
Extrajudicial line,
PW3,
PW3.
before fleeing from the place of occurrence is divorced the fact. What is something?
Should not take much time, Lordship. And to be honest, I am in a very tight corner, Lordship.
Yes, yes, it
Yes.
appears so.
Lordship. Lordship,
FIR, page four,
FIR, Lordship, page 4, Lordship.
FIR dated
Dated,
21,
Lordship, 21/8/18.
filed by whom, PW?
Filed by the Lordship father
P-
of the accused as well as deceased, Lordship. Is the
PW?
PW Lordship, he died, Lordship. He was not examined in court. Lordship.
Okay, you was
He
not
died.
examined. Then page, what does it say?
Page 4, Lordship, may I read, Lordship?
Yes,
Sir, I have the honor to state that around 7:30 PM on 28/2018, my middle son, that is the above named accused, picked up a quarrel with my youngest married son, Samaru Gwala, inside our dwelling house, and with the intention of killing him, he caused grievous injuries to him by attacking him with sharp meat chopping knife. The injured was immediately taken to Bishnath Civil Hospital by the ambulance of the T State for treatment, but the doctor declared Samaru Gwala dead. I therefore pray to you to take the necessary steps against the accused and obliged. Thereafter, Lordship, charge sheet was submitted and charge was framed under section 302 IPC, Lordship. Page 6, Lordship. And page 7 is the Lordship committal order, Lordship. And deposition of PW1, Lordship will find it page number 8. And Lordship,
who's PW eight?
PW1 is the Lordship wife of the deceased, Aruti Gwala.
Yes, what does she say?
Oh, no, Lordship. Accused Arjun Gwala is the elder brother of my husband. Nirmal Gwala is my father-in-law. My father-in-law is no more. The informant, Lordship, is no more. He died about 2 months ago. One day, about 1 year ago, my husband Samaru Gwala returned home from his work. He went to take a bath after telling me that he would have rice. After taking a bath, when he came to change his dress,
You would have rice, I think it mean you would have food.
food.
You would have most probably said bhat or something like that.
Here they say like
Yes, food. After taking a bath, when he came to change his dress, the accused assaulted my husband inside the room. He stabbed him in the belly with a knife. I went to the nearby kitchen to fetch water for my husband. When my husband screamed, "Ma," I entered the room in which my husband was. After stabbing my husband with a knife, the accused fled the scene. Holding my hand, my husband said to me, "Arjun has stabbed me." Earlier, the accused had been threatening my husband and me that he would assault us. When my husband pulled me by holding my hand, I also fell down with him. Then my sister-in-law, wife of my husband's elder brother, my father-in-law Nirmal Gwala, my mother-in-law, whose name I have forgotten, my husband and I were at home. Thereafter, we took my husband to the civil hospital. Then my husband had a little bit of sense. My husband expired after he had been taken to the civil hospital. Entering the room, the accused asked my husband why he had assaulted Baba. Whereupon my husband realized that he had not assaulted Baba and told him to ask Baba about it. Thereafter, the accused stabbed my husband. The police called me to the police station and questioned me there. This is the chief of PW1. That accused Lordship asked the elder brother that why he has assaulted Baba, the father. To which he replied that he has not assaulted Baba and told to ask Baba about it. And in cross Lordship, the accused and my husband are consanguine brothers. My husband worked in the tea garden. It happened at night and it was dark then. At the time of occurrence, the accused was in our house for 5 to 10 minutes. Though the accused did not stay in his own house, he sometimes used to come to the house to take bath. No quarrel took place between my husband and father-in-law, but my sister-in-law, wife of my husband's elder brother, she was not wife of the accused, she was not examined, falsely said that the accused had been assaulted. The accused came after consuming liquor. No quarrel took place between the accused and my husband earlier. The accused came carrying a knife with him. I was just a little bit away at the time of the occurrence and no quarrel ensued between them then. I did not find the knife at the place of occurrence. I came there first. After
Who
the
is Baba? Who is Baba?
Baba is the father,
Informant.
Informant.
informant, father of the both. After the incident, my in-laws went out.
What is this consanguine brothers?
Blood relation,
Blood related.
consanguine.
Literal.
I was in an unconscious state when the police arrived there. My father-in-law consumes intoxicated substance and he consumed some on the day of the occurrence too. It is not a fact that I have adduced false evidence against the accused. Then Lordship PW2. PW2 Lordship is a hearsay witness, Lordship.
Okay. Who is he?
He is a co-villager. Co-villager. Page 11, Lordship.
Okay, hearsay, don't no need. Then let's go to the next.
Next Lordship, PW3 Lordship Suman Gola,
Who is
cousin of the accused.
cousin of accused?
Cousin of the actually accused and deceased both.
Actually. If he's
On-
cousin of one, he has to be the cousin of the
Okay.
other.
On oath. Accused Arjun Gwala is the son of the elder brother of my father. Informant Nirmal Gwala is the elder brother of my father. The incident took place in the evening one day about 1 year back. At the time, I was at the center. When I returned from the center at 7:30 p.m., my younger sister Monisha Gwala, Monisha Gwala was not examined, told me that accused Arjun had stabbed his younger brother Samaru Gwala in his belly with a knife-like weapon. He was taken to the civil hospital. When I went to the
So this is also hearsay.
Now, there is a extrajudicial lordship will go to the cross-examination
Yes.
part.
When I went to the civil hospital to see him, I found that he had already died. The police station was informed of it, whereupon the police came there. Police questioned me when they came to the place of occurrence. I do not know what article the police seized. The police had obtained my signature before the dead body was taken away for postmortem examination. Exhibit 1 is the seizure list, wherein Exhibit 1 is my signature. Then also cross part. I could know about the incident in the house itself. I did not witness the incident. I did not go to the place of occurrence. Monisha did not witness the incident. After making the assault, the accused returned to our house and said that he had assaulted his younger brother.
Itu mana? Thereafter.
Thereafter, he fled. My mother and I went to the civil hospital and we could learn there that my cousin deceased had died. It is not a
Wait,
fact
who
that
is the elder brother? The deceased is the elder brother or what?
deceased is the younger brother. Elder one is the accused, appellant.
Or deceased the younger brother?
This is younger lordship.
But let us see just a minute. Come to PW1. Accused is the elder brother of my husband. Okay, okay.
Elder brother.
Okay. Then page 15.
Page 15 lordship. He is the VDB secretary lordship. Village Defense Party.
So he's also hearsay.
He is also here, sir, lordship.
Neighbor said,
Then
Then PW5 page 17.
mother.
He is the mother lordship.
No, not that.
mother.
Mother lordship. Although he was at the house lordship,
Yes, she-
but
no knowledge.
she did not witness the incident. She did not know as to how Samaru died. The deceased died.
She is not here. Yes.
Okay.
Yes.
Correct.
He was the lordship washing some utensil outside.
Page 19.
Page 9
PW6.
lordship, doctor who conducted postmortem lordship.
Penetrating wound.
And lordship, there admittedly there is lordship injury
Penetrating wound.
3 by 0.5 cm piercing up to peritoneum at right supra lateral area of the umbilicus. And lordship, the cause of death, the death was due to cardiovascular accident
Okay,
following severe internal hemorrhage.
next.
In a cross party admitted though the chip puncture was done by a blunt object from his back. The impact of the injury may be done by punching. If the person falls with a force in a blunt object, the said injuries may be caused. That part is there in the cross lordship.
Next,
And PW seven, page 21 is the IO lordship. He is the original IO. Later on, he retired and some other IO came into scene and he filed charge sheet. But he was not examined.
who was not examined?
The
The
IO,
second.
the second IO, who has submitted the charge sheet,
He's not
he is
examined.
not examined.
So is it fatal to the prosecution case?
As a normal rule, lordship, the IO who is to be examined.
Should be,
Because
but then will it vitiate the trial?
He is the IO, investigating officer is this one.
No,
In-
he's saying that there were two IOs.
Two IOs.
PW seven is the IO who done everything. But the submission of the charge sheet had been done by the second IO who was not examined. That's what he said.
The succeeding IO collected the postmortem
Ah,
report and submitted the charge sheet.
What prejudice?
Otherwise, lordship, everything was done by the earlier IO. As it is apparent.
okay, so he's the first IO.
He is the first IO,
Second IO not made a witness.
not made a witness.
So collected the
lordship postmortem report. And submitted the charge sheet. Page SI Manik Bormude.
okay, then
Then lordship, 313 CRPC examination lordship will find it in
Yes.
24 lordship. Apparently, he has admitted the lordship incriminating evidence
where?
at page number 24, 25 lordship, question number 2, question number 3, I don't know, question number 4. Yes, it is true. Yes, it is true. Then page 26. He has admitted.
Oh, he has admitted.
Only thing is that on the last question, question number 9, page 27. He has said that I know nothing. On the date of occurrence, I went for work and after returning from work at our residence, found that rice were scattered and as such, I came out from our residence and met my father on the road, who took me to Biswanath Chariali PS and handed over me to police. So he took a plea of lordship alibi, lordship, that his father handed him over to the police. When he arrived at the scene, rice were scattered.
But everywhere else he said it's true.
Lordship, yes,
You see, question
most of-
number
most of-
7 also,
most of the question, lordship.
question 6 also.
7, 6, 5, 4, and question number 2.
Handing over to the police was on a subsequent date, but he wrote on the date of occurrence.
Lordship.
Because he surrendered, he first fled away, it is said, and then surrendering was later. So, but then,
He didn't, he was not arrested on the same date.
no, he was not arrested.
surrendered.
Yeah, it is said he fled. And then he surrendered 2 days later, 2 days,
Not 2 days, on 21.
21.
Next day,
Acha, next day.
next day.
Next day. So in his explanation, perhaps he's talking about the next day.
All are not true. Yes, it is true.
Yes, it is, yes, that apart from 2 questions, all the questions were answered in the positive.
Basically, he's admitted.
He has admitted, basically. Although there is no direct witness, direct evidence.
But he has
circumstances-
admitted. Now then what remains? No alibi at all. In fact,
Alibi has to be proved, lordship. He has not adduced any defense evidence.
And the answer to these questions, he may mean the next day.
Huh?
He might have meant the next day, when he was taken by the father to the police station for
Yes.
surrendering. Can
He
be.
came there and saw that rice were scattered. And thereafter, he was taken to the police station by his father. And he was handed over to police.
Nothing to bring down, no?
So what remains?
That's why, lordship, initially I submitted that I'm in a very tight corner, lordship.
Circumstances were called out by the trial
I'll
judge.
quote, lordship.
He should have given some reason why he did it at least.
Yes, to bring it down or
To
something.
bring it down.
Only one sentence we get that he assaulted his father. And so that grudge was was
That-
in her,
No, that was, he had made the accusation. That was denied
The accusation was made by the deceased.
by
He denied.
by the accused. Accusation was made by the accused to the deceased.
To the deceased. Yes, yes, yes. He denied.
He denied it.
That should not be. Grievance.
This is a jail appeal. Can you just look at the yes, I think this is the one. Just let them read. Read it out loud.
This is
So that-
lordship
Ah,
in particular.
yes, that's why.
this is
If
the
I-
letter, I think, by the accused.
প্রতি মাননীয় মহামান্য গুৱাহাটী উচ্চ ন্যায়ালয়ৰ ন্যায়িক দণ্ডাধীশ মহোদয় সমীপত মাননীয় বিশ্বনাথ জিলা কাৰাগাৰৰ অধীক্ষক মহোদয়ৰ জৰিয়তে তাৰিখ 19/4/2021 বিষয় এপিল কৰাৰ বাবে আবেদন আবেদনকাৰী the applicant is the appellant.
This is the letter by accused.
This is the letter.
কৈ দিছো গোটেইখিনি।
মাননীয় মহোদয় সন্মানপূৰ্বক বিনতি নিবেদন এই যে অধীন বিশ্বনাথ জিলাৰ বিশ্বনাথ চাৰিআলি আৰক্ষী থানাৰ অন্তৰ্গত নীলপুৰ চাহ বাগিচা লেবাৰ লাইনৰ স্থায়ী লোক হওক অধীন বৰ্তমান বিশ্বনাথ
He is still
জিলা
labor working
বিশ্বনাথ
as.
জিলা কাৰাগাৰৰ এজন যাৱজ্জীৱন সশ্ৰম কাৰাদণ্ডী অধীনক যোৱা ইংৰাজী 33/2/2021 তাৰিখে হত্যা গোচৰত বিশ্বনাথ সেচন আদালতৰ অতিৰিক্ত সত্ৰ ন্যায়িক দণ্ডাধীশ মহোদয়ে যাৱজ্জীৱন কাৰাদণ্ডৰ লগতে 10,000 টকাৰ জৰিমনা সহ কাৰাদণ্ডৰ নিৰ্দেশ দিয়ে জৰিমনা অনাদায়ে অতিৰিক্ত 6 মাহৰ কাৰাদণ্ডৰ নিৰ্দেশ দিয়ে মাননীয় মহোদয় অধীনৰ ঘৰুৱা আৰ্থিক অৱস্থা অতি শোচনীয় অধীনে বিশ্বনাথ জিলা সেচন আদালতৰ অতিৰিক্ত সত্ৰ ন্যায়িক দণ্ডাধীশ মহোদয়ৰ ৰায়দানত মুঠে আত্মসন্তুষ্টি পোৱা নাই গতিকে দয়ালু মহোদয়ক বিশ্বনাথ জিলা কাৰাগাৰৰ অধীক্ষক মহোদয়ৰ জৰিয়তে পুনৰ বিচাৰৰ বাবে আবেদন জনালো
No, nothing. He has just said that I have
Just
been.
read, just read the last 3 sentences.
ডাউন বিলো এই যে মহোদয়ৰ ওচৰত সৰল প্ৰাৰ্থনা ইতি মহোদয়ৰ বিশ্বাসী কাৰাবন্দী অৰ্জুন গোৱালা বিশ্বনাথ জিলা কাৰাগাৰ
গতিকে I have applied for.
গতিকে দয়ালু মহোদয়ক বিশ্বনাথ জিলা মাননীয় মহোদয় অধীনৰ ঘৰুৱা আৰ্থিক অৱস্থা অতি শোচনীয় his financial condition is very bad অধীনে বিশ্বনাথ জিলা সেচন আদালতৰ অতিৰিক্ত সত্ৰ ন্যায়িক দণ্ডাধীশ মহোদয়ৰ ৰায়দানত মুঠে আত্মসন্তুষ্টি পোৱা নাই he is not satisfied with the judgment of rendered by the
Does he say that he is innocent?
No, he said he is not satisfied.
he is
with
not
the
satisfied with the finding
judgment.
of the trial
So what is that? He says that it's wrong or what?
He did not say anything. He simply said, I have been inflicted those
That-
punishments and
yes.
I'm not satisfied.
and
and
my financial condition is very bad
that, and so I request for a rehearing.
for an appeal he is nowhere stated that he is innocent
Perhaps he wants his imprisonment to be brought down.
Is it possible? There's nothing.
I don't find any exceptions that can be.
but lordship only thing lordship can see that lordship when he lordship alleged his younger brother that he has assaulted Baba, the father. And when the deceased replied that he did not assault him. Thereafter, lordship, he has inflicted the blow.
No, he had come with the intention with the
So
knife.
that, whether that will come, bring the present case into any of the exception, the grave and sudden provocation or sudden fight, these two only may come into play.
But
But-
where is the provocation?
That is there when he replied in negative. Like he told that you asked Baba about.
If he replied in the positive, okay, maybe. But if he replies in the negative, where's the provocation?
No, that provocation was not at that point of time earlier. He was already provoked, so he had come to kill.
Yes. And
Assault him.
No,
or-
so that provocation has to be within a
Ah,
short span of time.
yes, proximity has to be.
Yeah, proximity has to be there with
And
the
also
act and the provocation.
And the PW1 further said that from earlier also he was threatening. That he would
Very difficult.
difficult, that is why lordship.
hmm.
And admittedly, he went there with a knife, that alleged weapon.
And there is no contradiction.
Knife
also.
was recovered.
Knife
Knife
was
was
seized
seized
from his possession.
from his possession.
I think he took the knife when he surrendered.
Yes,
Oh, when he surrendered.
he took the knife and
So what has happened is he committed the crime on 21/8, is it?
on lordship 20.
28th.
On 28
20.
at 7:30. Then he surrendered when?
On 21st.
On 21st something.
It is in the statement of the lordship IO PW 7
Surrendered on 21.
21.
Then surrendered, okay, with the knife.
With the knife,
it
with the knife.
seems. But in the Caesar list, it is said it is produced by the father.
Lordship may kindly see the
But then they went together.
They went together. Father took him.
The IO said, Lordship, arriving at the police station, I came to know that Arjun Gwala had surrendered himself to the police in the police station and that he had handed over the knife with which he had killed his younger brother. The knife was seized from the possession of the accused. And it was Lordship
For the possession of the
accused. And it was Lordship seized by Caesar his Lordship, Exhibit 3.
Okay, yes,
And
anything else?
Lordship may kindly see the circumstances which the learned trial court Lordship called out. Page number 46. Para 54, Lordship.
Yes,
In view of the above prolonged discussion, the following circumstances are appearing. Accused was found coming out of the room of the deceased Samaru after the incident on the date of occurrence. Deceased Samaru reported his wife just after the incident that accused Arjun stabbed with knife in his belly. Deceased Samaru raised alarm as Ma and PW1 at once went inside the room of the deceased. PW5 being mother of the deceased heard the alarm of the deceased and went to the PU. PWs 2, 3 and 4 coming to know about the incident that accused Arjun Gwala killed his brother Samaru went to the house of the deceased and thereafter to hospital where they found Samaru in dead condition. PW4 being VDP secretary took the deceased Samaru to hospital where doctor after examination declared Samaru as dead. During examination by doctor, PW4 noticed cut injury and bleeding on the belly of the deceased Samaru. Doctor during examination found penetrating wound of size 3 by 0.5 cm, piercing up to peritonia of right supralateral area of the umbilicus. Accused voluntarily surrendered at police station with the knife, weapon of offense. Police seized the weapon of offense by Exhibit 3, Caesar list. Police also seized the blood-stained gamusha from the PO by Exhibit 1, Caesar list. These are the circumstances.
so there's nothing for you to latch on to lower the sentence.
Only thing Lordship can consider is that whether he was provoked.
How?
Or whether there was a sudden fight.
No, you show us that. It is you who has to show us. And you see, the provocation has to be equivalent or proportionate.
Proportionate.
Ah,
That Lordship entering the room, the accused asked my husband why he had assaulted Baba. Whereupon my husband replied that he had not assaulted Baba and told him to ask Baba about it. Thereafter, the accused stabbed my husband.
Then, that is the provocation. Where is the provocation?
Admittedly, he went there with a knife. That part is there.
And if he says he did not do it, ask Baba. That provocation and the act, they are not proportionate.
Yes.
That-
Should be proportionate.
That's all.
And some of the witnesses who could have thrown some more light were not examined.
They were not arrayed in the
Wife
charge
of,
sheet also.
wife of the accused.
Well, the accused was also present.
She was,
Was she present in the view?
In fact, the wife of the deceased said that wife of accused was there, no?
wife of the deceased.
And
Anyway,
she said, then my sister-in-law, wife of my husband's elder brother. So perhaps she is the wife of the accused.
no, there was another elder brother.
Or
There was another elder brother.
Oh, acha, acha, there was another elder brother. But he in his 313 perhaps is married. No.
Married is mentioned.
Huh?
Mentioned. Then lordship that the PW3 cousin said that when he lordship returned from the center,
Ah, yes.
PW3, who is the cousin lordship, he
Ah.
said that while after returning from the center at 7:30 PM, his younger sister Manisha Goala told him that the accused Arjun had stabbed his younger brother Samar Goala in his belly with a knife-like weapon. Manisha Goala was not also examined. Who could have thrown some more light, along with the wife of the accused.
Along with the wife of the accused. So he was married.
Wife of the page number 9. Page 9, lordship will find last portion lordship. No quarrel took place between my husband and father-in-law, but my sister-in-law, wife of my husband's elder brother.
No, he might be someone, some other elder brother.
Falsely said that the accused had been assaulted. It is not clear whether she was his wife or some other.
Okay, anyway, with the evidence that is there. What is there to hide?
It was not falsely stated. This is what had happened.
Now, what is there to hide? Can there be another story? He was the only one who came in. He was the only one who stabbed. He's the only one who his father. Now imagine your father taking you to a police station.
Hmm.
What more do you want?
And father lodged the FIR.
Father lodged the FIR. Knife is, you have surrendered the knife yourself. What more do you want?
His statement was recorded in the, by the police under 161, the father.
Ah.
Nirmal Gwala.
Ah.
No, Nirmal, no?
Nirmal.
Nimal Kaur, Nimal Kaur.
He said what? So possibly you can read as well. The father said,
161 of the informant. মোৰ নাম ঠিকনা ওপৰত দিয়া ধৰণৰ মই দিন হাজিৰা কাম কৰো যোৱাকালি সন্ধিয়া 7:30 মান বজাত মই ঘৰত থকা অৱস্থাতে মোৰ মাজু ল'ৰা শ্ৰী অৰ্জুন গোৱালা আৰু মোৰ সৰু ল'ৰা সোমাৰু গোৱালা দুইটাই কিবা কথা লৈ কাজিয়া কৰে
oh, so there was a quarrel before
কিবা কথা
the
লৈ কাজিয়া
assault.
কৰে আমাৰ নিজৰ ঘৰত পিছত মোৰ
For some reason they were
পিছত
quarrel.
মোৰ মাজু ল'ৰা অৰ্জুন গোৱালাই চুকা মাংস কটা চুৰি এখন লৈ সৰু ল'ৰা সোমাৰু গোৱালাক পেটত চুৰি সুমুৱাই দি গুৰুতৰ জখম কৰে
After that, he brought the knife and then he had assaulted.
Oh, so he went home, went somewhere, then got. the knife.
Then perhaps even the wife said that initially he did not come with the knife, but later on he brought it.
So there was, so whether grave and sudden provocation would be applicable then.
But we cannot take recourse to 161.
That also 161, they know it
cannot.
hasn't come out in
161,
evidence.
161, yes.
That also of a
Hmm,
dead person.
that also for that person. We cannot bring section 33 also because that had to be a judicial proceeding. This is not a judicial proceeding.
Unlucky.
Lordship, that is
Even the wife PW1 in her statement before the police said that the knife was brought later. But then not there before the
Or
trial.
maybe they could have made an application under 391.
Hmm. 391
Additional evidence.
for examining wife of the accused and all.
Wife of the accused and maybe PW3. PW3 sister.
PW3 sister.
Yes.
They were not irritated now.
To enable them to, so they could have made their, ask for a court witness or something. To enable them to make out a case under one of the exceptions. But then they're not done what to do.
If it is the case that he has gone and brought the knife, then lordship could have.
No, if he has gone and brought the knife, then there's no case. There's no case for bringing the exception. It has to be in the spur of the moment.
The quarrel part is also not there in these evidences before the
Correct,
trial.
correct,
court.
that's the problem.
Wild part is there in the 161 statement. That
F-
cannot be
FIR
That also by the father.
by the father.
If the father had been alive, maybe something could have been.
Something
Yes,
would have
yes.
happened. But in the FIR, it's there. They picked up a quarrel with my youngest son. Quarrel part is only there in the FIR, which is again not substantive.
The mother also told that I do not know what happened between my son Samaru and Arjun. Arjun assaulted his younger brother Samaru, but I do not know how he had assaulted him. Absolutely.
No. No, who, I mean, the said witnesses were not examined by police also. These are the witnesses who were examined by the police. Police did not bring the other witnesses. So even 391 will not,
Anyway, so we'll, I don't think there's any escape.
he is in jail throughout from the date of his arrest.
Yes,
When is that?
No, in the order sheet I've seen,
Which year?
2018,
2018
21, 8, 2018.
till now. Nobody,
The day he surrendered, since then,
nobody is there to bail him out also.
yes,
Actually, maybe all the male family members are dead.
yes,
or-
yes, yes. Allegedly, he has killed his brother. The mother and sister would not have come forward.
Maybe he'll get remission and whatnot sometime in the future. he's
Difficult
lucky.
here in the appeal.
Huh?
Difficult in the appeal.
Yes, I don't think we can do anything.
Without taking any recourse to the exceptions, if your lordship simply says there was no intention on his part, I cannot, I don't think so. Wait, assets, yeah.
Because blow was,
No, no,
there
this
was a
was
single
like-
blow.
IPC or 5%?
Blow was lordship single, one blow.
One blow in
One
the abdomen, perhaps. No, 300, I think, in the main section,
300.
300. We cannot go into the exceptions. None of the exceptions will come. Because there are no materials. 300, except in cases hereinafter accepted, culpable homicide is murder. If the act by which the death is caused is done with the intention of causing death or. Acha, these are murder only. Except in the case hereinafter accepted.
Hmm.
So exceptions is only this. No, 300 will not come.
And also lordship, he did not have that instantaneous death. He died later on in the hospital. So death was not instantaneous. So, and also lordship, one single blow. So had there been a premeditation to kill him, he would have inflicted some.
But then the problem is with, it's a knife. No? The weapon used.
It's available in
It's a
everyone's house.
meat
Ah,
chopping.
now, supposing you use a stick
Hmm.
and
One blow.
suddenly it happened, then okay.
And he was intoxicated. He was under the influence of
But
liquor.
then that does not help.
That does not help. But liquor, he brought the knife. If at all, it can be converted to 326.
No, because liquor, to take advantage of liquor, then it has to be shown that he was forced to drink it.
Forced to
Yes,
be
yes, he could
given.
not voluntarily
Yeah.
have taken.
No, we cannot take those grounds
Those-
here.
Yes.
But 326 dangerous weapon, if it at all can be converted, single blow. He did not die instantaneously. He was taken to
Yes.
the hospital. And there was
Dangerous,
I'm trying to somehow.
because you have got to think of not only this case, this is not the case. Now, if we make any decision on that, might have repercussions in other cases.
Other cases.
There was only one blow. Then now they will only go one blow, 2 blows,
And
half a
High
blow later on.
and High Court doesn't have the Supreme Court power, only in this case we are
Yes,
doing it.
yes, yes,
141 is not
yes,
there.
yes.
Also, 391 appellate court may take further evidence or directly to be taken. So there are immediately two of the witnesses who would have thrown some light were not examined by the
I don't
lordship.
think so. That will be helpful for the defense.
Some may come out, something may come out.
That would be more
They were
helpful
not
for the
there.
prosecution.
At the time of the incident. There's nothing to show that they were there at the time of the incident. You see, if it was the wife of the accused, why wasn't she made a defense witness? If
Yes,
there was
yes, yes,
something
yes.
favorable.
Yes, yes. She was not examined by defense.
Ah. So that is there also.
And lordship also, there is no lordship assumption that someone else might have committed.
No,
Only
no, nothing,
he was there.
nothing.
Father said before police they were quarreling and
Ah.
father perhaps was the eyewitness. He had
Father.
seen.
Later on, he died.
Perhaps.
So examining some other witnesses will not help defense. Perhaps it will help more the prosecutor.
Anyway,
At all, if it can be converted to 326, lordship can ponder.
no, we are trying to see if something, but nothing appears on the horizon. Right. Heard Mr.
And Hassan lordship.
N. Hassan, learned amicus curiae. Also heard Miss El Jahan, additional PP. This appeal has been filed against the impugned judgment dated 30/03/2021, passed by the additional session judge bracket FTC, Biswanath Charyali in sessions case number 50/2019, by which the appellant has been convicted under section 302 IPC for murdering, for killing his younger brother. Correct? Younger brother. Full stop. The appellant was thereafter sentenced to undergo rigorous imprisonment for life with a fine of rupees 10,000, in default to undergo simple imprisonment for 6 months. Full stop. The next para, the prosecution case in brief is that an FIR dated 21/8/2018 was submitted by the father of the appellant to the officer in charge B/Charyali Police Station, stating that around 7:30 PM on 20/08/2018, the appellant picked up a quarrel with his youngest son inside their house with the intention of killing him. Full stop. The appellant attacked the youngest son with a sharp meat chopping knife, causing grievous injury. Full stop. The injured was taken to Biswanath Civil Hospital by ambulance. Full stop. However, he died on the way or what?
Lordship.
He
He
died
died on
at
the
the
way.
hospital.
That is hospital.
In the
Where did
hospital,
he die?
the doctor declared him dead.
That's what I'm saying. Because however, the deceased was declared dead at the time he was brought into the hospital. Full stop. In pursuant to the FIR, B/Charyali PS case number 2005/18 under section 302 IPC was registered on 21/8/2018. Full stop. Next, after investigation was completed, comma, the investigating officer, bracket IO, submitted a charge sheet submitted a charge sheet, comma, on finding a prima facie case against the appellant under section 302 for having killed his younger brother. So there were three brothers. Because says the middle son is the accused.
Middle son.
Three brothers.
Three brothers. First one. Charge under section 302. CIPC was thereafter framed, was framed by the learned trial court against the appellant, comma, to which he pleaded not guilty and claimed to be tried. Full stop. Next para. The learned trial court thereafter examined 7 witnesses and after examination of the appellant under section 313 CRPC, comma, came to a finding that the appellant was guilty of having killed his younger brother. Full stop. The appellant was thus convicted under section 302 IPC and sentenced accordingly. Full stop. Next para. The counsel for the learned amicus curiae submits that the evidence of the cousin of the accused, cousin of the appellant, bracket PW3, is to the effect that he had heard of the appellant, no, he had heard that the appellant had caused the death of his younger brother Samaru Gowala, SAMARU GOWALA, from his younger sister Manisha Gowala. Full stop. However, Manisha Gowala was not made a witness by the prosecution. Full stop. Anything else? What is your submission going to be? He also submits that while the first IO bracket PW7 had done the investigation, comma, the second IO had collected the post-mortem report and submitted the charge sheet. Full stop. However, the second IO was not examined by the learned trial court. Anything else?
Lordship may kindly record that provocation part on being instigated.
Okay, he also submits that the appellant was provoked by the deceased, as the evidence of PW1
PW1.
showed that the appellant had asked the deceased as to why he had assaulted the
Father.
assaulted their father, comma, to which which was denied by the appellant, by the deceased, which was denied by the deceased. That's all. That was the provocation. That's difficult. Yes, anything else? Yes, can you help him, please? What to add? Difficult submission. What submission will you make?
And he told him to ask Baba about it.
Okay,
And-
okay. Puts up, denied it and told the appellant to ask their father about.
And thereafter, the accused stepped her husband, the PW1,
That is not required.
as per PW1.
It was full stop. It was because of the said provocation that the appellant stabbed his younger brother.
And lordship, that one blow. That
Full
has
stop. He also
given-
submits that as there was only one one stab. He also submits that as the appellant had stabbed the deceased only once. Comma, the same, showed that there was no intention to kill the appellant. The intention to cause the death of the appellant. He ac- he accordingly praised that the conviction should be made under the exceptions to section 300
300,
part, section 300 IPC.
exception 1.
Okay, exception 1 of section 300 IPC. That's all. Okay, right, next. For her, there's not to say, I think. Miss,
Homicide is accepting, only
Huh?
bringing. Homicidal that he is accepting, only bringing it down, he is submitting.
correct,
So
he has
that
to, there's no other, there's no submission to be made. No, that's the
Yes.
problem.
One cannot argue for acquittal, because
Yeah.
That's why at the beginning I told that I mean tight corner lordship. So far as this. And that his conviction may be altered to section 304, that may be recorded.
326 also, if you can.
326 also.
Then just cite accordingly, accordingly, the conviction of the appellant should be
Altered.
accordingly the sentence of the, accordingly the appellant should be sentenced under section 304
4,
part 2,
Part-
part 1,
part 2.
IP.
326, death has resulted. No, death may result, still it can be given. His intention was only to cause grievous hurt. I think 326.
Later on he died, so 326 may not come.
Hmm.
Had he been alive, then lordship. He will
No,
not.
there are so many cases where Supreme Court has converted to 326 the death matters. Resulting in death only hasn't
And-
voluntarily causes. No, Supreme Court of Course, it doesn't matter. The means of any heavy or any instrument used is likely to cause death. Or by means of fire, by means of a. Which it is very, sorry. That part is not there, but then I have found so many cases, Supreme Court has converted it to, in the facts. If he dies after 2-3 days, then also Supreme Court has stated this.
It's not more important.
Okay, anyway, that's all right. Say, Miss S. Dahan, additional PP, comma, on the other hand, submits that the deposition of PW1, who is the wife of the deceased, and the extrajudicial confession made to PW3, which is reflected in the cross-examination of PW3, coupled with the doctor's evidence proves that the appellant had caused the death of the deceased. Full stop. She further submits that the father of the deceased had submitted the FIR and had in fact taken the deceased, the appellant to the police station. Full stop. Further, the weapon, bracket knife, had also been seized from the possession of the appellant, when he surrendered before the police station. Thus, the above facts really having proved the fact that the appellant had caused the death of the deceased, the impugned judgment passed by the learned trial court should not be interfered with. That's all.
Bringing it down is also not possible. But that's lordship will give the finding.
We have heard the learned counsels for the parties. Full stop. As can be seen from the from the trial court records, the FIR had been filed by the father of the deceased and the appellant. Full stop. It was the father of the appellant who had also taken the appellant to the police station where the appellant was arrested. The knife bracket weapon was also recovered from the possession of the appellant at the police station. Next para. Come down. Go. The evidence of next part, the evidence of PW1, who is the wife of the deceased, is to the effect that the accused had come into their house and when PW1 went to the kitchen to fetch water for her husband shouted. Screamed is more of a feminine thing, I think. You don't say that a man screamed. Anna, men are supposed to be tough, they're not supposed to scream.
Lordship.
Shouted. What have I said? Shouted bracket ma, M-A-A, ma. Ma. Then now you got it. Full stop. On entering the room, PW1 saw the accused fleeing the scene. After having stabbed her husband with a knife. Her husband held her hand and told her that Arjun had stabbed him. That Arjun, inverted commas, Arjun has stabbed me. Arjun has stabbed me. Inverted commas close. PW1 also states that the appellant had been threatening her husband and herself by stating that he would assault them. Full stop. When her husband pulled her down, when husband pulled her by holding her hand, she also fell down with him. Full stop. Thereafter, her sister-in-law, father-in-law bracket informant, and mother-in-law comma husband and she were at home. And herself were at home, and herself were at home. Thereafter, they took their husband, they took the deceased to the civil hospital. However, her husband expired after he had been taken to the civil hospital. After he had been taken. She also stated that when she had entered the room, the appellant had asked her husband as to why the deceased had assaulted their father, whereupon the deceased had replied that he had not assaulted their father and told the appellant to ask their father about it. So thereafter, the appellant had stabbed her husband. So it appears that she saw it.
How will she otherwise come to know? But
Ah,
perhaps she was told by her husband.
no, husband will also say, stabbed,
Stabbed.
it can be
Along
said
with
since-
that,
yeah.
along with that.
Huh?
Because otherwise it seems she was not inside the room. She
She was in
went
different
to
room.
fetch water. away.
Then she shouted, yes, yes.
Perhaps husband only told her.
First up. Anyway. Because this is after they went to the hospital.
Huh.
Anyway. Next. In her cross-examination, PW one states that no quarrel took place between her husband and her father-in-law. Though her sister-in-law falsely stated that the accused had been assaulted, falsely stated that the appellant had been assaulted. No meaning.
He said that the appellant had been assaulted.
Appellant had been assaulted by whom? Had been assaulted. PW further states that PW1 further states that the appellant had consumed liquor before coming to their house, and that no quarrel had taken place between the appellant and the deceased earlier. The appellant came carrying a knife. And after the incident, her in-laws went out to call a vehicle. That's all. These are useless. No meaning there. All random questions are no meaning.
Cross-examination.
What they're
also-
trying to achieve also nothing is there.
Because what she said is accused did not stay.
Huh?
She said accused did not stay in his own house.
No, I'd say the other thing. Like what is
Assaulted.
like father-in-law consumption of liquor, what has that got to do anything with the incident?
Cross-examination
Even
was
the
done
pri-
very casually.
Even the prior statement, she said accused did not stay in his house. He was there for 5-10 minutes in the house of the deceased. Then he sometimes used to come to the house to take bath it seems that accused was staying separately, not
Yeah,
at all with them.
Maybe,
Maybe.
I'm not sure.
To take bath.
Because there was a sister-in-law. Now, which sister-in-law we don't know.
Sister-in-law, we don't know.
Because the appellant is the middle brother.
Maybe.
Next, the evidence of PW1, who is a villager, is basically hearsay, as he had heard from others that the appellant had stabbed the deceased. Person. The evidence of PW3, who is a cousin of the appellant, is to the effect that he had been told by his younger sister Manisha Goala that the appellant had stabbed the deceased. Full stop. Thereafter, he went to the civil hospital to see him. Full stop. In his cross-examination, no, so he further states that he did not see the incident of the appellant seizing the appellant no, he did not say that also. In his cross-examination, he states that PW3 states that he did not witness the incident. Full stop. However, after the assault, the appellant returned to their house and told him that he had assaulted his younger brother. Bracket deceased. Thereafter, he fled. Full stop. Next paragraph. The evidence of PW4, who is the village defense party secretary, is hearsay, in as much as he had been told about the incident and was not an eyewitness to the same. Full stop. Next. The evidence of next para, the evidence of PW5, who is the mother of the appellant and the deceased, is to the effect that she did not have any knowledge as to how the deceased died, as she did not witness the incident. Next para, the evidence of PW6 is to the effect that he was the senior medical and health officer at Behali Block PHC on 21/8/2018, where he conducted the post-mortem examination of the body of the deceased. The PW6 states that there was one penetrating wound of 3 into 0.5 centimeter size, piercing up to peritoneum at right supralateral area of umbilicus. Don't say that. Don't say that. Submits that the following injuries were seen by him, which is as follows. That is at page 20 from here to here. Okay. Full stop. In the opinion of PW6, death was due to cardiovascular following. It's here again. Just look at it. He also states that the puncture on the body was done by a blunt object. Full stop. Next part. The evidence of PW7, who was the first investigating officer, is to the effect that while he was on duty as sub-inspector of police in Biswanath Charyali, Biswanath Police Station, comma, the VDP secretary informed the police station over phone that the appellant had caused grievous injury to his younger brother by stabbing him with a knife. Accordingly, GD entry number 608 dated 20/08/18 was registered and he went to the place of occurrence. There, he learned that the appellant had stabbed his younger brother and fled the scene. A sketch map of the place of occurrence was drawn and he seized some blood-stained clothes which were lying there. He took the statements of two witnesses and went to the Biswanath Civil Hospital, where he learned that the deceased had died. On arriving back at the police station, he came to learn that the appellant had surrendered himself to the police and handed over the knife with which he had killed his younger brother. The knife was thereafter seized. On 21/8/2018, the father of the appellant lodged an FIR in connection with the incident and the same was registered. Inquest was done on the dead body and the same was sent for post-mortem examination. As he retired from service on 31/1/2019, he handed over the CD to the OC. The succeeding investigating officer collected the post-mortem report and submitted the charge sheet. In his cross-examination, PW7 states that he did not get the knife examined by a forensic expert and he had seized one gamocha in the house. The examination of the appellant under section 313 is basically to the effect that he has admitted to having stabbed his younger brother in the belly. And that his father had taken him to the Biswanath Charyali police station. Next. On considering the above facts, we find that the evidence recorded by the prosecution witnesses, especially PW 1 and 3, coupled with the evidence of the doctor, bracket PW 6, proves the fact that the appellant had killed his younger brother. So further, his admission during his examination under section 313 CRPC also corroborates the no, first of all, also the evidence recorded corroborates the no, also his explanation given under section 313 CRPC corroborates the evidence that the appellant had caused the death of the deceased. Full stop. Next para. Though the learned amicus curiae had taken a stand that the second Dio had not been made a witness in the case, we find that no prejudice has been caused to the appellant on account of the second investigating officer not having been made a prosecution witness. We also find that the informant, that is the father of the appellant, had not been made a prosecution witness, as he had died prior to the trial proceedings having commenced. What else? No.
Back in the charge sheet.
Huh?
Charge sheet only he was shown as dead.
Prior to filing of
The fact is also clear from the, huh? What have I said? The fact is also clear from the charge sheet where the death of the informant has been mentioned. Next, on considering. No, with regard, next para, with regard to the submission of the learned amicus curiae, that exception one to section 300 IPC can be attracted to the facts of this case, we find that there is nothing in the evidence to attract the said provision. In as much as the answer given by the deceased to the appellant that he had not assaulted his father and to ask their father about it cannot, in our view, amount to provoking, cannot amount to provocation. Full stop. In any event, assuming there was some provocation from the deceased, which resulted in retaliation on the part of the appellant, it is settled law that retaliation has to be proportionate to the provocation. Full stop. In that view of the matter, we do not find any ground to, we do not find any reason to come to a finding that the case of the appellant comes within the first exception to section 300 IPC. Anything else? In that way of the matter. In that way of the matter, there is no ground made out to interfere with the impugned judgment dated so and so, passed by so and so, in so and so case, huh? The appeal is accordingly dismissed, send back the LCR, then fee of the amicus curiae.
We have a different division bench tomorrow.
Acha, already, who?
Yes, Justice Kalyan Surana and Justice Ete.
Okay, okay. And there is a single.
Lordship has a single bench.
Okay.
And Lordship is going out.
I'm going for a few days. I've got one meeting,
That's
an important meeting to attend to, and then after that, some other work. I'll be back during that independence.
Lordship.
Lordship,
Of like,
our life. Judgment. Kali case पे ही है।
yes. কি ক্রস করে দেখছেন
Translation ঠিক হয় না বেয়া অসমীয়া
তাকেতো
কোনটো অসমীয়া হেতু কৰিব নোৱাৰি
অ
ট্ৰান্সলেচন ঠিকে কৈছে আৰু
এই এডমিন কিয় কৰিছে গোটেই বস্তুবিলাক 313 হয় বোলে সব সঁচা বোলে ইট ইজ ট্ৰু আৰু কি কৰিব ও অনেস্ট মানুহ তাকে কনভাৰ্সনৰ কোনো উপায় নাই সব সঁচা বুলি কৈ দিলে ন
কালি আৰু তোমালোকক আকৌ ডিউটি দিয়ে এহিপিনো কৈ আছো দিবি কোনটো অ ডলাৰ হ'ব
কোৰ্টৰ ওপৰত খালি ন আপুনি থাকিব খালি ন
আৰু ফোন কৰিছিলা কোৱা আচ্ছা হোৱাটছএপত চাই লওঁ